Today, I'm going to talk about the consequence of the recent Supreme Court order by which the judgment in the case of Benami Property Act, wherein several provisions of the unamended Benami Property Transaction Act 98 were struck down, and it was held that the Benami Prohibition Amended Act 2016 has a prospective effect. So my objective is to analyze and discuss the effect of this particular judgment, whether the entire outcome of the judgment, wherein it was held that the Benami Transaction Prohibition Amendment Act is prospective in nature, whether that is also gone, or whether only it has an effect on the constitutionality part of the judgment, wherein several provisions of the Benami prohibition of Benami Property Transaction Act 1998 was struck down. Now, I must give you a big background of the matter. The Benami Property Transaction Act 1998 was having only 9 sections. It was a very short act. Section 8 empowered the government to prescribe a procedure for implementation of the act. That was never done. So, prohibition of Benami Property Transaction Act 1998 remained a dead letter because it was never implemented. In 2016, Chapter 2 to Chapter 7, covering Section 7 to 72, were inserted by the Benami Transaction Prohibition Amendment Act 2016 with effect from 1/11/2016. So as you can see, the act itself, from a small act which covered only 9 sections, the act was substantially amended by covering 72 sections in the act. And the rules which were never issued prior to 2016 were also issued to implement the law. So the question before the Honorable Calcutta High Court was whether the so-called notice, which was issued subsequent to the amendment of the Act, that is 29th August 2017, whether it can cover the contravention of the Act which took place in 2011. So the issue was that the Act in 1998 was merely a shell act. It was only on paper. It was inoperative. And by addition of so many sections, the act has substantially been amended, and the definition of the Benami property itself, its acquisition and the penal provisions have totally taken a new color. So in view of such a wide amendment of the act, whether the said amendment can be said to have a retrospective application. That means if an offense under the Prohibition of Benami Property Act has taken place prior to the amendment, whether the punishment under the new amended act can be given to the concerned person, whether to the Benamidar and beneficial owner. One important point is that in the new amended act, there is a definition of Benamidar and there is a definition of beneficial owner also. And there is a provision for punishment of. So this entire act whereby you see there is a provision for punishment of Benamidar, that is the person who is a fictitious person in whose name the Benami property is held, and the person for whose benefit the Benami property is held by a Benamidar. Both were made liable for punishment. And there was a provision for acquisition of the Benami property also. Now, this was the only issue before the Honorable Calcutta High Court, and the Honorable Calcutta High Court held that this, since there is a substantial amendment in the law and the contravention of the 1990 Act cannot be said to be resulting in contravention of 2016 Act when the offense has taken place in 2011. So therefore, there cannot be any retrospective application of the law. Now the matter was taken to the Supreme Court by the Union of India, and it was argued by the Union that it is not that an offense is sought to be implemented retrospectively, but merely the procedures are laid down to implement the Act of 1988. And Pre-Amendment Act already recognizes Benami transaction as contrary to law. Hence, no new or substantive law has been made in the amended 2016 Act. Now, to answer this question, the Honorable Supreme Court said that answering the above question is inevitably tied to an intermediate question as to whether the 1998 Act itself was constitutional in the first place. So even though no arguments were advanced by the either side with respect to the constitutional validity of any of the provisions of 1988 Act or 2016 Amended Act, the only issue which was framed for consideration was whether the new amended Act in 2016 has a retrospective application. The Honorable Supreme Court said that, look, we cannot answer this question without looking into the constitutional validity of several provisions of the old Act. So, Honorable Supreme Court said that in the Indian law, one of the important aspects is that there must be a mens rea. It is an essential ingredient of a criminal offense, which is missing in the 1988 unamended Act. The Honorable Supreme Court said that mere fact that the object of a statute is to promote welfare activities or to eradicate a grave social evil itself will not be a decisive to question as to whether the element of guilty mind is excluded from the ingredient of an offense. The Honorable Supreme Court said that a statute may by expressly providing for it may exclude the element of mens rea, but it cannot be by way of implication. And it is obvious that the 1988 Act left loose ends, and on a bare reading of the Act, it appears that prosecution only have to prove that the consideration was paid by one person for another person and nothing more. So there is absolute absence of mens rea in the S5 provision, and therefore the provision is very harsh. Secondly, the Honorable Supreme Court also referred to Section 5, which provided for the power for acquisition of the property, which is a Benami property, in such manner and after following such procedure as may be prescribed. Now, obviously, no procedure was prescribed. So, therefore, Honorable Supreme Court said that Section 5 is also very harsh and arbitrary because there are certain essential ingredients which are missing in Section 5. Honorable Supreme Court said whether the proceeding under Section 5 were independent or dependent on successful prosecution, where what is the standard of proof required to establish Benami transaction in terms of Section 5, mechanism for providing opportunity for a person to establish his defense. No defense of innocent owner was provided to save legitimate innocent buyers. No adjudicatory mechanism was provided for. No provision was included to determine vesting of acquired property. No provision to identify or trace Benami properties. And lastly, the Honorable Supreme Court said that the condemnation of property cannot include the power of tracing, which needs an express provision. So the Honorable Supreme Court said that it was an inconclusive law which left the essential features to be prescribed to delegation. The gaps left in 1988 Act were not merely procedural, rather the same were essential and substantive. And in the absence of such substantive provisions, the omissions create a law which is fanciful and oppressive at the same time. And such an overboard provision was manifestly arbitrary, as open texture of law did not have sufficient safeguards to be proportionate. So effectively, the Supreme Court said that, look, the provision were not having the substantial provision. It is not only that the procedural provision to implement the law was missing, there was absence of the essential and substantive law also in the unamended act. So both the key provision, that is Section 3 of the old act and Section 3, which provided for prohibition of Benami transaction, and Section 5, which provided for acquisition of a Benami property, were struck down by the Honorable Supreme Court, while at the same time holding that the provisions are prospective in nature. It was held by the Supreme Court that Section 3(1) of the 88 Act is vague and arbitrary. Section 3(1) created an unduly harsh law against settled principles and law commission recommendation. Section 5 of the 1998 Act, the provision relating to civil forfeiture, was manifestly arbitrary. I've already said there were 8 reasons listed by the Honorable Supreme Court to say why Section 5 is manifestly arbitrary. So the Honorable Supreme Court said that having arrived at the aforesaid conclusion, so that Section 3 and 5 were unconstitutional under the 88 Act, it would mean that the 2016 amendments were in fact creating new provisions and new offenses. Therefore, there was no question of retroactive application of 2016 Act. As for the offense under Section 6, Section 3(1) for those transactions that were entered into between 5/9/88 to 25/10/2006, the law cannot retroactively invigorate a still bold criminal offense as established above. So, the Honorable Supreme Court virtually struck down the 1988 Act and said that only the 2016 Act can be said to be an act which has some meaning and which is meaningful, and therefore it was struck down. So, Honorable Supreme Court, it is not that in the vacuum the provisions were struck down. The provision were struck down while answering the question whether it can have a retrospective application, and the court said that, look, we cannot answer this question without going into the validity of 1988 Act. It is true that the validity of 1988 Act was not questioned by either side or not argued also. But in order to answer the question, the Honorable Supreme Court ventured into this issue and struck down this particular provision. Now, by way of this very recent October 18 judgment, the Honorable Supreme Court has allowed the review petition of the Union of India on the ground that it is undisputed that there was no challenge to the constitutional validity of unamended provision, and it was held that a challenge to constitutional validity of a statutory provision cannot be adjudicated upon in the absence of a lease and contest between the parties. Accordingly, the review petition has been allowed. And the judgment of 2022, 23rd August 2022 was recalled. Now, the issue which immediately comes to everybody's mind is whether this recalling of the judgment, what is the effect of this judgment? Whether the judgment of the Honorable Calcutta High Court, which held that it cannot have a retrospective application, that also goes with this recalling of the Supreme Court judgment. My answer is no, because by way of a recalling of the judgment, it is not that the judgment of the Calcutta High Court has been set aside or it has been touched upon. It is only the judgment of the Supreme Court which has been nullified. So the 2022 judgment does not exist in the eye of law. Now, all that is alive is 2000, Calcutta High Court judgment, which is a judgment dated December 12, 2019. So the issue which was answered in this 2019 judgment by the Honorable Calcutta High Court, that the Benami Property Act cannot have a retrospective application. In my view, whatever has been held by Calcutta High Court is not only having application to the jurisdiction of the Calcutta High Court, but it has all India applicability, because once the constitutionality of a act which has a effect throughout the territory of India is made, then it has an effect throughout the country. So since the Calcutta High Court has held that the 2016 Act, which is an amended Benami Property Act, can have only prospective application. So in my view, that judgment is still alive, and we can take the benefit of that judgment throughout India. And it is not that by virtue of the recall of this judgment, the Calcutta High Court judgment has also been set aside. So with this, I conclude my today's session. Thank you very much.